Guardianship is like kind of the same thing, except it's for lifetime issues where you lack capacity. If you lack capacity, that means like you don't.
So to clarify for everyone, Barry, this is
Yeah.
not guardianship for children that you may be thinking of. This may be your own capacity that you're lacking.
So that's a good question because
It's
actually both. It's actually both because technically minors don't have capacity. They don't have legal capacity. So like if you're inheriting, all right, this is a great question. It's a great question. So say you have a kid that's a minor that's inheriting over $15,000. You have to open up a guardianship. You have to open up a guardianship for that kid to be able for them to take possession of it legally.
I see this mistake all the time when it comes to life insurance beneficiaries, and one spouse will name their other as the primary spouse, may try and name their minor kid as the contingent beneficiary, and obviously children can't inherit large sums of money, let alone $15,000.
But the problem with that, I mean, like it's not fatal that it's a little bit more of an administrative burden and cost to get that result. But what the real problem is that they do get the control of that money at an early age, you know. So when they hit 21, they get control of that money. They can go to Vegas and they can roll it, you know, go to the win and roll it all in black. So if you're okay with that, then fine, do that. So guardianship is yes for minor kids, but also for when someone lacks capacity, like Alzheimer's, dementia, they can't take care of themselves anymore. Someone has to be appointed as their guardian. And guess what? A circuit court judge will decide for you unless you decide for yourself. And that process is not quick and it's not painless. It's kind of public. It's a bit humiliating. And it's really to be avoided. I don't see any reason, except again, in very few circumstances, to like intentionally go through a guardianship.
Not to backtrack, Barry, but going back to number one, in addition to costs and a lot of time, going into probate makes everything public, right? As well,
technically it's public record. I mean, it's not the easiest thing in the world to get to it, but yeah, it's public. So if you want privacy, that alone should tip the scale in favor of maybe putting into a trust, which is private. It's a good question. All right, so P&C. I'm sorry, P&G. Probate and guardianship. I think we covered briefly. You know, they're time-consuming, expensive, and I do think it's important maybe to talk about how much money we're talking about here. You know,
I think so. And also because of the fact, you know, we talked about things being drawn out over an extended period of time.
Yeah,
with your attorney there for over a year. You know, I think you can elaborate more on what that might look like.
Yeah. So, there's a lot of ways that attorneys charge for probate. I would say there's maybe 4 types. There's hourly, fixed, percentage, or some combination of those 3 things. And we do all of them. It just depends on the circumstances. For example, you know, a $50,000 estate, we're not going to take a percentage. It's just not going to be worth it to us. You know, versus a $100 million estate, we're probably also not going to take a percentage because that's not fair to the estate. So it just has to make sense. There's a lot of work. There's a lot of unpredictable things, but I would say a general rule of thumb is, you know, 10,000 plus, 20,000 depending on complexity, 50,000 if it's complex. If it gets litigated, ceiling, you know, I mean, that's a lot of money, and all of that could be avoided. All of it can be avoided. You know, so financially it's unpleasant, but also emotionally, psychologically, and familially. That's a word.
Speaking of familiarity, that I imagine could cause issues. Let's say if one child potentially has money and the other one doesn't, and they're contesting something in probate. I can imagine that could affect the outcome.
Only because I want to make sure we talk about it. I think that's kind of later, but let's talk about it.
Right, I didn't mean to jump ahead there.
No, it's fine. I mean, I don't know if we're gonna hit it because, you know, we enjoy this too much. If you have a situation where someone is at all questionable in terms of their capacity, or someone has a close relationship with someone else, and they're always together, and that person just happens to be the beneficiary or disproportionate beneficiary. For example, and this happens all the time, but this is real. So you get older, you're in your 80s, you have health problems, you got 3 kids, the good, bad, and the medium kid. The good one, they're very good to you. They take care of you. They drive you to doctor's appointments. They're at home. They help you with your medication. They check in every day. They're involved in your life. The bad one, they don't give a shit about you. They can't wait for you to die. They just want your money. They don't call you, don't visit, nothing. And there's the medium one, which, is somewhere in between. And so you go to the attorney and you say, look, the good one, they're wonderful. They take care of me. I'm so grateful for that. I want them to have more. I want the medium one. There's still hope for them. I want the medium one to have some, and I want the bad one, I don't want them to get anything. And say that this person has medical issues. Say there's even a glimpse of lack of capacity. Say there's facts that support that the good one was, taking them to the attorney, involved in the process. All of a sudden you have now a very convenient opportunity for the bad kid to challenge the estate planning and say, wait a second, you didn't have capacity to do that. Or alternatively, you didn't know what you were doing. Good kid took advantage of you to get a better deal. You didn't really want to do that. They made you do it. This kind of scenario happens all the time. And unfortunately, there's a lot of lawyers that will take the case because that's kind of what they're supposed to do. They believe one side. There's always 3 sides to every story. And they'll paint a picture, and that case will probably settle in a way that would make the person, the client, absolutely livid. And it's very sad to see that happen. It happens. And so we, as our firm, we kind of anticipate these types of problems. We really get to know the client, and we try to preempt those types of arguments by strengthening the file and, just really strengthening the file to prevent and mitigate those types of contests. So we'll run more later, but
while we're on the topic, as a follow-up, what are some things that you typically do to strengthen a file like that?
You're asking me for like our proprietary, intellectual property here.
We'll save it for another time.
Let's just say, look, I once you kind of do it enough times and you see how they're going to be attacked, how to fortify what you're doing. You can't eliminate the possibility that someone's not going to hire a lawyer and a couple Hail Marys, but you can maximize the likelihood that you'll succeed in your plan, and that's what we help people do. We don't guarantee anything, but we do our best to fortify and strengthen. And there's a lot of things it wouldn't make sense to talk about now.
Okay.
So that's number 1: probate, guardianship, the court system. Haimo.